Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, an intern at LEXCLIQ, and in today's video I will be talking about Articles of Association. The Articles of Association of a company are its bylaws or rules and regulations that govern the management of its internal affairs and the conduct of its business. According to Section 2, subsection 5 of the Act, Articles means the Articles of Association of a company as originally framed or as altered from time to time in pursuance of any previous company law or the present act, that is, the Act of 2013. In the case of Naresh Chandra Sanyal versus Calcutta Stock Exchange Association Limited, it was held the articles regulate the internal management of the company. They define the powers of its officers, and they also establish a contract between the company and the members and between the members inter se. This contract governs the ordinary rights and obligations incidental to membership in the company. They set out provisions for the manner in which the company is to be administered. In particular, they provide for matters like the making of calls, forfeiture of shares, directors' qualifications and appointment, powers and duties of auditors, procedure for transfer and transmission of shares and debentures. For the first time, Companies Act 2013 contains provisions relating to entrenchment from articles. Subsection 3 of Section 5 provides that the articles may contain provisions for entrenchment. What it means is that articles may provide that certain provisions of the articles will not be alterable merely by passing a special resolution, and they will require a more elaborate prescribed procedure to be followed. The provisions for entrenchment referred to above shall only be made either on formation of a company or by an amendment in the articles agreed to by all the members of the company in case of a private company, and by special resolution in the case of a public company. Where the articles contain provisions for entrenchment, whether made on formation or by amendment, the company shall give notice to the registrar of such provisions in such form and manner as may be prescribed. The Articles of Association of a company usually contain rules and regulations related to the following matters. First, the exclusion, wholly or in part, of the model articles as contained in respective tables. Second, share capital, shares and their value and their division into equity and preference shares, if any. Third, rights of each class of shareholders and procedure for variation of their rights. Fourth, procedure relating to the allotment of shares, making of calls, and forfeiture of shares. Fifth, increase, alteration, and reduction of share capital. Sixth, rules relating to transfer or transmission of shares and the procedure to be followed for the same. Seventh, lien of the company on shares allotted to the members for the amount unpaid in respect of such shares and the procedure in respect thereof. Eighth, an appointment, remuneration, powers, duties, etc. of the directors and officers of the company. Ninth, constitution and composition of audit committee, remuneration committee and CSR committee. 10th, procedure for conversion of shares into stock and vice versa. 11th, notice of the meetings, voting rights of members, proxy, quorum, poll, etc. 12th, audit of accounts, transfer of amount to reserves, declaration of dividend, etc. 13th, borrowing powers of the company and the mode of exercise of those powers. 14th, issue of share certificates, including procedure for issue of duplicate shares. And 15th, winding up of the company. The Articles of Association must be prepared carefully, and it must contain rules in regard to all such matters which are required to be contained therein and which are necessary for the smooth functioning of the company. But it must be remembered that the articles must not contain anything which is against the provisions of the Companies Act or the Memorandum of Association. For example, articles must not contain a rule permitting the payment of dividend out of capital because according to section 123, dividend can be paid only out of profits. Thank you so much for watching the video. Subscribe to the channel and see you in another video.